Mahama Ayariga is your friend.
Yes, he's my friend, my brother, and my colleague in
Is
Parliament.
he going to court today or not?
No, Mama Ayariga, he wouldn't go to court today.
Why not? Members of Parliament, any different? The laws that you make in Parliament, do they affect yourselves as members of Parliament, or is just for the others, us, and not you?
We make laws for Ghana. And everybody in Ghana, whether you're a Ghanaian or not, you have to comply with the laws of Ghana. And so,
so why is he not going to court?
And to be a member of Parliament, you must be a Ghanaian. So Mama Ayariga definitely is bound by the law.
Can I ask you another? Has he been served, apart from this letter that the special prosecutor wrote to the speaker, has he been served with a court document asking him to appear in court today?
I'm not able to speak to that, but I know yesterday I had a brief meeting with him in the presence of the minority leader. I must confess that Mama Ayariga raises interesting legal matters. People have different opinions. I do have a different opinion, but I share. I mean, I sympathize with his position. Probably I would not have done it that way. But he will not go to court. He intends to raise the matter on the floor of the House, and then we'll see what happens.
How does that work? Has this happened before, you know, this specific way that this is turning out to be?
Again, so we come back to the Dana Budapi matter. It didn't happen the way that is happening now. Because none of the earlier persons and references made to Sakande, who was member of Parliament for Boko, and Dan Abodakwe was member of Parliament for Anglo. Now, both did not raise the legal issue, the constitutional issue of immunities as being raised in a manner that is being raised by Ayariga. Now, but my understanding is that in the case of Dana Abodakwe, he raised the matter before the High Court, which was trying him.
So he appeared and then raised the
matter before the High Court. And the High Court granted him the permission to attend court only on Mondays. Okay,
so it wasn't the Speaker? Or it wasn't the Attorney General?
The Speaker doesn't give...
But it wasn't the Attorney General in this case? In that case that you cite, it wasn't the Attorney General that said...
Attorney General has no capacity to waive attendance to court.
But you get why I'm asking that...
I don't get it.
Okay.
I'll let you tell
No, that's fine. It's okay. We can leave it there. Okay. But I'm sure the people following the line of questioning would get the point that I'm trying to make. So the interesting thing is the court that says, okay, you can come to court only on Mondays. In the case of Dana Abodakwe.
So that's why I say that, well, I would not have done it the way he has done it. But I respect the position he has taken. As a legal practitioner, as an accused person, I'll go to court and raise the jurisprudential issue.
Okay.
Because the Speaker has already written to the Special Prosecutor, telling the Special Prosecutor that, or informing him that Ayariga will be engaged in parliamentary duties and that he will not be available to attend court on days that Parliament will be sitting. Now, the Constitution says that when the Speaker does put pen to paper and say those things will be conclusive. And you know, evidence degree, what conclusive evidence means.
But there was a response from the Special Prosecutor, wasn't there?
Well, I'm saying that that's conclusive. It's conclusive. The only thing is to argue on whether member of Parliament, who is appearing as an accused person, is caught by the provisions of the law, as stated in 118. But that is conclusive evidence. Okay? So it's not even for the Special Prosecutor to say that, well, I won't go by it. That's conclusive. So you go to court and say, look, I've invited Ayariga to come before me, and then the Speaker has written to me to say that Ayariga will be engaged in parliamentary duties. Can you fix court date for Monday?
Isn't that also a bit of difference in terms of the processes? Because, and I want to make it very simple, and let's use you. The AG has a case against you, and so the court summons you. What business has the AG writing to the speaker to release you? Because I'm looking at it in the sense of, but this is no longer a matter of, this is court now serving you.
Because you're a member of parliament. I mean, it is, I mean, to say that you can just walk to a member of parliament and invite him to court to appear before court is to assume that a member of parliament doesn't occupy any special place in the governance architecture of this country.
But
unless you're just
the rule of law, does the rule of law recognize the structures and where you belong?
I don't think that the rule of law does. That is why in the rule of law, procedure is very important. And so it says that a service on the member of parliament, if served on the clerk, constitute good service. Okay? So, and the rule of law requires that if the speaker releases the member of parliament, that member of parliament is bound to attend to whatever summons that has been. It's part of the rule of law. In fact, in Moshi and Bajina, it stated very clearly that rule of law is as important to substantive law as it is to procedure. You can't say that substantive law applies to everybody. And so, because there are different procedures applying to different persons on the same substantive law, those persons who enjoy certain privileges for which the procedure will have to change to accommodate those privileges are treated differently. You must also go follow those procedures. If you fail to follow the procedure, then you'll be violating the ethics of the rule of law. And so, it's just that...
So this is just following due...
To put it more generally, if a law says that something can be done, it is in doing that, if the law also provides the way that thing should be done, you must not only do what the law says you can do, but you must do it in the way the law says it should be done.
Okay.
Yes.